Good afternoon, everybody. My name is Christy Johnson. I'm a workers' compensation claims consultant with LP Insurance. A lot of you in the room, I think, are our clients, and most of you have probably heard about subsequent injury from either your producer or one of us work comp consultants. So we're very fortunate today to have attorney Tim Rowe from McDonald Corona Wilson here to talk to you guys about subsequent injury fund. Mr. Rowe represents a variety of large clients, from large gaming establishments to small businesses. His clients include many of the most prominent gaming, manufacturing, and political entities in the state. His areas of expertise include employment and labor law, construction law, commercial and complex litigation, and gaming and administrative law. A large portion of Mr. Rowe's practice, and the one that LP utilizes the most, is representation for employers for workers' compensation claims. He's handled a number of high-profile cases involving death and serious injury, and has also argued a large number of cases before the Nevada Supreme Court. So we are truly privileged to have him here today, so if you will all help me and give him a warm welcome.
Thank you very much. Can everybody hear me okay? Okay, I apologize if I tend to look over my glasses. I need them to read, but I don't need them so much for distance, so that's what I look over them a lot. Our topic today, subsequent injury fund, is kind of a little small area of workers' compensation law, but it can be really important to employers and insurers in terms of protecting themselves when dealing with employees who have disabilities and prior injuries. And so what I intend to do today is kind of talk about what the subsequent injury fund is, why we have it. I want to go through some of the specific requirements for it, and just kind of give you what I would call an overview of subsequent injury and how to deal with it, in the hopes that at some point you can use it to your benefit. I want to encourage everybody to ask questions as we go through. If you have a question, just stick your hand up and I'll try to answer it. I don't guarantee I'll know the answer, but if I don't, we'll find it and get it to you. So feel free to ask questions. These things go a little better, I think, sometimes when it's more of an interactive process than it is just me lecturing up here. So feel free to ask questions. The first thing I have to do is that. What I'm doing is not legal advice, and this does not create an attorney-client relationship. According to our malpractice carrier, if I don't do that, I get in trouble. So that's why that's there. So if you have specific questions or you want to talk about a specific case or something, we can do that. But if you decide you need legal advice on it, then get a hold of me later, and we'll deal with it. Before we get right on the topic, what I would really like to do first is, how many people here get regularly involved in industrial insurance claims? Okay, so fair number. And how many of you just kind of occasionally get involved in those claims, not too often? Okay. And how many of you have ever been involved in a subsequent injury claim directly? Okay. Anybody do it all the time? Okay, good. All right. So why do we have a subsequent injury fund? What's the issue here that underlies all of this? And to talk about that, what I'd like you to do is think back 50, 60, 70 years when we didn't have ADA, we didn't have FMLA, we didn't have wrongful termination law, we didn't have Title VII discrimination claims. And suppose that you've got, that you're an employer and you've got a worker who you know has got a bad back. In our little example up here, 2 herniated discs, okay? And workers' compensation law at that time is evolving, and somewhere along the line, about 60, 70 years ago, it became apparent that employers that have injured workers and who are employing people who have problems and they aggravate those problems, they become fully liable for those claims. So that was a principle of workers' compensation law that developed over time, and it made it clear basically that you as an employer take your employee as you find them. And so in this case where you've got an injured worker with a bad back and say he's doing a difficult job labor-wise and hurts his back and can no longer work, is totally disabled, you, that employer, are responsible for that claimant in that condition at that time, regardless of what his pre-existing condition is. Okay, now, think about the fact that there's no ADA, no FMLA, no wrongful termination, no Title VII discrimination. What are you going to do as an employer when you realize you've got a disabled worker and that if he happens to aggravate that condition in your employment, you're responsible for him or her? What are you going to do? You're going to let him go. You're going to find a place, you're going to find a way to fire him. And it was actually an interesting phenomenon when this principle of law first came out and people learned that they were responsible for the employees as they found them in the workers' comp setting. When that principle became well known, somebody did a study, and it turned out that people with obvious disabilities were terminated at about 10 times the rate they had been before that law basically became in effect. And they actually did the study in Oklahoma where the law took effect, and immediately people without hands, feet, arms, legs got fired just like that. On the other hand, think about somebody who, in that situation 60, 70 years ago, when an employee comes to you and they're missing a hand or a foot and they want a job. What are you, as that new employer looking at a disabled individual, going to do? Are you going to hire him? No, you're not. Okay, so this becomes a big problem. People with disabilities, with impairment, first of all, get fired, they can't find work, and so forth. And what evolves is this idea of, and at the time, what it was called is a second injury fund. If you look, anybody know what Larson's is? Larson's is kind of the definitive text on workers' compensation law. If you look back in Larson's, you'll see that the evolution of these funds started out as second injury fund is what they call them. But the idea is to take the cost of a subsequent injury with somebody with an impairment or a disability and spread it across all employers, not just the specific employer hiring the person, but across all employers, all insurers, so that there's no specific problem or issue if a particular employer hires the disabled person. And what we have in Nevada is we've developed this subsequent injury fund, and that's what it's called, the subsequent injury fund. Insurers are assessed by DIR to basically accumulate this fund that covers subsequent injuries. And actually the assessments are for more than just the funds that are being covered, but for example, it covers the fund for workers' compensation and safety. Uninsured employers claim fund is funded through these assessments. Subsequent injury accounts are funded through these assessment. And in Nevada, we have three specific subsequent injury funds. We have a fund for self-insured employers. We have a fund for group, private, and public self-insured employers. And we have a private carrier's subsequent injury fund. Now, the requirements for all of these funds are pretty similar, so what we're going to do today is basically talk about the fund that deals with private carriers. So the statutes and the regs that I'm going to talk about are the ones that deal with private carriers, but there's equivalent statutes and regs that deal with these other funds for self-insured employers and group self-insureds as well. Okay. Okay, here is the primary statute. And I'm going to read this, and then I want you to think about what I read to you once I finish. And you, if you can, what I want you to think about is whether you can tell me when and how subsequent injuries are covered under this fund. If an employee of an employer who is insured by a private carrier has a permanent physical impairment from any cause or origin and incurs a subsequent disability by injury arising out of and in the course of his or her employment, which entitles the employee to compensation for disability that is substantially greater by reason of the combined effects of the pre-existing impairment and the subsequent injury than that which would have resulted from the subsequent injury alone, the compensation due must be charged to the subsequent injury account for private carriers in accordance with the regulations adopted by the administrator. That's a pretty complicated statute, and there's a lot in that paragraph. And so in order to kind of understand it, you have to dissect it, and that's what we're going to do a little bit today. All right, so first part of that, if an employee of an employer who is insured by a private carrier has a permanent physical impairment from any cause or origin. Anybody know what a permanent physical impairment from any cause or origin is? Well, there's a subsequent provision in the statute that tells us, and it's subsection 3. And what it says is, permanent physical impairment means permanent condition of whether congenital or caused by injury or disease. So it can be anything that basically impairs somebody in terms of disability type issue. It doesn't have to be caused by industrial injury. It can be, a source can be disease, it can be congenital, it can be anything. But it has to be of such seriousness as to constitute a hindrance or obstacle to obtaining employment or to obtaining reemployment if the employee is unemployed. Okay? So it's two things. It's a permanent physical impairment, but only if it would cause a hindrance to employment. Okay? And then finally, there's the provision that says, for the purposes of this section, the condition is not a permanent physical impairment unless it would support a 6% whole person impairment if evaluated under the AMA guides. Everybody know what the AMA guides are? Those are the guides that rating physicians use to rate impairment and disability. So if somebody has an industrial injury, when they reach the end of the industrial injury, if they have permanent impairment, they get a rating, and a rating physician will use the AMA guides to rate them. And what this is saying is that permanent physical impairment has got to rise to the level of 6% or more of a whole person. Okay? But one of the things that's important to remember is that just because you've got a 6% whole person impairment, it may not qualify if it's not something that would hinder employment. Okay, so basically, you've got to meet all of these conditions to have a permanent physical impairment. So it's just not just a 6% disability necessarily. Most 6% disabilities would constitute something that might hinder employment. So you're probably going to qualify, but not necessarily. Okay, let's see. All right, second part of the statute incurs a subsequent disability by injury arising out of in the course of his and her employment. So the important point here is you're not necessarily going to qualify for subsequent injury account recovery if you have a subsequent injury. You've got to have disability by injury. Okay, so you can have a serious industrial injury that may cost you a ton of money that may not end up causing disability at the end of the claim. If it doesn't cause disability at the end of the claim, you're not going to qualify for subsequent injury fund protection. So it's got to be disability by injury. Okay, what about diseases, occupational diseases? What happens if you have somebody who has pre-existing permanent impairment, has an occupational disease that aggravates that condition? Is that going to qualify for subsequent injury? Yes. Statute doesn't say it's going to be covered, but DIR has reluctantly taken the position that an OC disease that aggravates a pre-existing condition will be potentially covered under the fund. And a good example, I had a case here a couple years ago where we had a fireman that had multiple knee injuries over the course of his employment, and those knee injuries eventually developed into bad osteoarthritis to the extent that he needed knee replacements because of the osteoarthritis. We filed the subsequent injury claim, and we did battle with DIR for a while, but they eventually agreed that that aggravation or the knee replacements that were caused by the osteoarthritis were going to be covered under the fund. So they will cover aggravation by occupational disease. Okay, the next part of the statute, which entitles the employee to compensation for disability that is substantially greater by reason of the combined effects of the pre-existing impairment and the subsequent injury than that which would have resulted from the subsequent injury alone. What does combined effects mean? Anybody know what they're talking about? So let me give you an example and see if we can sort this out. Suppose you've got somebody who has a pre-existing knee injury. In this case, we'll say it was an ACL issue with moderate laxity. Okay, and if you look at the guides, an ACL injury with moderate laxity will be a 7% impairment. Okay, so we've got pre-existing condition that looks like it would qualify. It meets the 6% requirement. Depending on what the particular occupation is, it may or may not be a hindrance to employment, but let's assume that it is for this purpose. Okay, the employee then has a subsequent knee injury where basically they end up with a total meniscectomy in the knee. So we'll say it's a medial meniscectomy. And again, if you look at the guides, that's going to be an additional 3%, so you've got additional disability. Are you going to be able to get coverage for that additional 3% disability? Anybody want to guess?
Not necessarily.
You are correct. And the reason you are correct is because of this combined effects issue. Now, the position that DIR will take on this particular example is that these are not identical body parts, and that subsequent injury would have resulted in the medial meniscectomy regardless of whether or not the ACL condition had been there. So they're going to take the position there's no combined effects because that subsequent disability isn't worse because of the initial ACL reconstruction that had been done. Now, I'm looking for the case that I can take in front of DIR to fight with them over this. And the reason I want to fight with them over this is the guides require regional impairment to be combined prior to determining the total level of whole person impairment. So if you look at the guides, anything in the knee has to be combined as a lower extremity impairment before you can determine whole person impairment on this. And so my position is that because the guides looks at the knee as basically one body part for purposes of determining whole person impairment, you can make an argument that DIR is wrong and that this particular injury should be covered because when you combine them as a whole person impairment, it's worse. I don't know what the answer to that is, but I'm looking for the right case and the employer that wants to fight with DIR so I can see what happens. We'll see. All right. We looked at 3. All right. Under subsection 4 of the statute, to qualify for reimbursement, private carrier must establish by written records that the employer had knowledge of the permanent physical impairment at the time the employee was hired, or that the employee was retained in employment after the employer acquired such knowledge. Okay, so there's a specific knowledge requirement here.
Can I ask a question?
Yeah.
So if I have someone who, in a, just out of conversation, or I actually have this happen, we said I had a doctor's appointment, I have bad back, going to have a doctor look at it. So I say, would you hurt yourself working for us? No, I've had it for years, I'm working for, any trades for long periods of time. So I documented the conversation, told him to work outside of business trade, giving restrictions, make sure he lets me know, yada, yada. Would I have had to say, do you have a permanent physical impairment at that time in order for that to potentially be covered if he hurt his back again later?
No, I don't think so. I think the fact that you documented the conversation and your knowledge that he had a, quote, bad back. In other words, he's told you that he's got some degree of disability or impairment. He's not quantified it, but he's let you know he's got a problem that could affect his employment. And so if you've documented that in written records, then I think you're gonna be fine. Okay.
If you ask the employee when you're hiring if they have any impairments that would restrict them from doing this, or permanent impairments, and they say no, and later you find out it is, they still may qualify, is that correct?
Yeah, we're going to talk about that.
All right.
Okay. There's a lot of issues with
All right. I'll let you go.
asking, about impairments, and we're going to go into some of that. So, so there's a couple of points here that I want to go through. First is looking at this idea that you have to have knowledge of permanent physical impairment, and again, it's not just prior injury; it is some degree of impairment. Okay, and in your example, I think there was enough information there that you could say you knew he had some degree of impairment. Okay. At the time the employee was hired, or that the employee was retained in employment after the employer acquired such knowledge. Okay, so I want to talk about a case we have here in Nevada. This case, to be exact. In this particular case, what happened is there was a husband and wife who were co-managers of a retirement residence. The wife, in the course of doing her job, had a back injury, a lumbar sprain. The MRI that was done a couple of weeks later revealed that she had had prior surgeries on her back, and that was the employer's first knowledge of the pre-existing condition. So the knowledge occurs after the subsequent injury. She then goes on to have her third back surgery and eventually goes back to work, works for the employer for a year, and then retires. Okay? The Holiday Retirement Corporation and their insurer requested subsequent injury protection on that claim, which is essentially the third surgery claim that they had, and basically contending that they retained that woman in employment after they had knowledge of her prior impairment. Okay? DIR denied the subsequent injury fund claim, and they took the position that the employer and the insurer needed to have, the employer needed to have knowledge of that subsequent or prior condition before the subsequent injury. Okay? Now, if you read that language, it doesn't say anything about having knowledge prior to the subsequent injury. It just says you have to retain them in employment after the employer acquired such knowledge, which appeared to have occurred in the Holiday case. Well, that case went through an appeals office, it went through the district court, and eventually went up to the Nevada Supreme Court. And I want to read what they say about this, because this is interesting and it affects these claims. Court said, majority of jurisdictions that have considered such knowledge requirement within the context of the subsequent injury fund have held that an employer must acquire knowledge of the employee's permanent physical impairment before the subsequent injury occurs to qualify for reimbursement. This interpretation recognizes the critical difference between an employer who retains a permanently physically impaired worker before a subsequent injury occurs and one who retains a permanently physically impaired worker after the subsequent injury has occurred. In the former situation, the potential for liability remains contingent. In the latter, the potential for liability is certain. Permitting reimbursement in the latter situation is akin to providing an employer an option to buy casualty insurance to cover a casualty that has already occurred. And so the court held that you have to have knowledge of the condition prior to the subsequent injury. And in this case, they denied recovery to the Holiday Retirement Corporation because they didn't have that knowledge prior to the subsequent injury. So that's established law in Nevada at this point. You need to be able to establish by written records your knowledge of the prior disability or impairment prior to that subsequent injury.
But I thought you can't ask that question.
We'll get to that.
Okay.
Okay, so basically, just recapping for a minute, those are the essential requirements that you need to have in order to qualify for reimbursement under the subsequent injury fund. And it's all expressed in that one paragraph, and it's when you break down the various parts of that, you'll see the specific requirements that basically are necessary to qualify. Now, if you will recall, the wording of the statute basically charged DIR with making regulations that in order to carry out how the subsequent injury fund is administered. Well, these are the three particular regulations that deal with that, and there's just a couple of things I want to point out. NAC 616B763 identifies the things you can recover in a subsequent injury fund claim. There are a number of things you cannot recover, and what I want to go through is what you can't recover. You can't recover the reserves on the claim. Now, I don't know, most of you probably know that when an industrial insurance claim comes in, the insurer will look at that and they'll reserve it, and they'll say, okay, we think this claim is going to cost $100,000 by the time it's done. You can't recover for reserves. You can only recover your actual expenditures on the claim. Any money paid on the claim in excess of statutory compensation is not recoverable. I'm not exactly sure what that would be, and I can't really imagine insurers agreeing to pay out more than they're statutorily required to pay. So I think that one's probably not going to happen very often. If you have a litigated claim, you cannot recover your litigation and legal fee expenses for that claim. If your insurer is required to pay interest at any point in the claim, you're not entitled to recover that. You can't recover your administrative expenses in the claim, and you can't recover denied claim costs. So it may be in the course of the claim, you expended costs on the claim. Well, let me step back. How this would happen is you get a claim, you deny it, it goes to hearing, you're ordered to pay, you pay because you can't get a stay, it goes to appeal, and it's reversed, and it becomes a denied claim. Well, you can't submit or try to get recovery on those claim costs because it's a denied claim. Okay, people have tried that, and it's been held that you can't do that. You do have a right of appeal. If you file a subsequent injury claim and it's denied by DIR, it goes before the subsequent injury board. The board will make a decision based on DIR's recommendation. If that claim is denied, you do have a right of appeal, and you can go directly to the appeals office as you would in an industrial insurance claim. In a typical claim, you go to the hearing level, then you go to the appeals level, then you go to the district court. On subsequent injury claims, you go directly to the appeals office. You do not go through the hearing office, and you've got 30 days to appeal that decision from the subsequent injury board. And I will tell you that if you submit a claim and it goes to the board, you need to stay on your toes because it may take them 8, 9 months, maybe a year to get you a decision on those subsequent injury claims. So you really have to pay attention because that decision will come through. You've only got 30 days to appeal it. The next thing I want to talk about is NAC 616B 760. And 760 is a regulation that provides for this little gem, which is the DIR Form 37. Let me get that. DIR Form 37 it is not for the faint-hearted. I don't know if any of you have dealt with this form, but what it is, it's the checklist that you have to use as an employer when you submit, your insurer or employer, when you submit the claim for subsequent injury reimbursement. And if you go through this thing, you'll see that it's a very exacting form and requires extensive documentation. And I will tell you, if you get one thing out of order, it's going to get kicked straight back to you to do over again. And in my opinion, this form was designed to make it difficult to get subsequent injury fund recoveries. I think this thing was intentionally made this way. I probably shouldn't say this, but I think DIR they guard the subsequent injury fund like it's a treasure chest that belongs to them. And it is difficult to get recovery on these claims. If you have a massive claim that has got 6-8 inches of records and litigation and whatever, it takes a lot of work to put that claim together in the manner that this particular form requires you to do it in order to submit for recovery. My advice is that if you have a complicated subsequent injury fund claim, you probably need to find somebody that's familiar with doing it in order to get these claims submitted. It's just not an easy process. Okay. Proof of knowledge. Okay, so how do we as an employer find out about prior impairment and disability in our employees? And as you all know, we currently have the ADA. And the ADA says that you cannot conduct a medical examination or make inquiries of a job applicant as to whether such an applicant is an individual with a disability or as to the nature or severity of such disability. However, a covered entity may make pre-employment inquiries into ability of an applicant to perform job-related functions. Okay? So you can ask an employee, an applicant, can you perform the essential job functions of this job? And that's as far as you can go. under the ADA. You cannot ask them if they have prior impairments, you cannot ask if they have disabilities, and you cannot ask any specific information about any of that. Okay? I want to jump forward here for just a second. Make sure I get the right one here. Okay. On the other end of the scale, we know the ADA says you can't ask a current employee about disabilities or impairment unless you have a specific job-related reason for doing so. Okay? So once you've hired somebody, you can't go ask them what kind of impairments or disabilities they have. Okay? So applicants you can't ask, employees you can't ask. So what do? How are you going to get this knowledge, and how are you going to get it in writing? Well, the answer is there's a very small window where you can get the information. Okay? And what the ADA says is that you can make a conditional offer of employment may be made to the applicant contingent on the results of a physical and medical examination, but only if all employees in the same job category are required to take such an examination, regardless of disability, and the medical information is obtained and collected and maintained in separate forms and in separate medical files. Okay, so you've got this little small window, post-offer pre-employment, where you can ask these questions. Okay? And there's no limitation to what you can ask in that period of time. Okay? They can be broad as you want to ask the questions. So what you can do as an employer is you can make an offer of employment. You can look at your list of applicants, decide which one you want, make an offer conditioned upon completion of medical forms, application forms, whatever. In other words, in this small window, post-applicant, pre-hire, you can ask the questions that you need to get the information to qualify for a subsequent injury fund. Now, this scares the crap out of most employers. The ADA has everybody so intimidated that they don't want to go near the issue of who's got disabilities or impairment. It just scares everybody to death. But the ADA specifically allows for this information to be gathered in this post-application pre-hire period.
Excuse me just a moment.
Yeah.
You can't just use this not to hire somebody, because if they have an impairment but it has nothing to do with the job duties that they have, you can't exclude them.
Right.
From the job.
Yeah, and you have to be very careful. And this is what this deals with here. The EEOC takes the position that the offer to the employee for employment has to be a real offer. I mean, you can't just make an offer that's not really a real offer so that you can try to get the information to determine. I mean, if the EEOC or somebody suspects that you're doing that, you're going to get called on it and you're going to get sued. Okay? So the offer that you make has to be a real one. And for example, I mean, what you'll see a lot of times in the mining industry is that mining companies will make an offer of employment to an employee contingent upon them passing a physical and they'll actually send the employees out and do a complete physical to determine whether they're physically capable of working at the particular job that they're looking at or they're potentially hiring for. Okay. There's really no difference between doing that and basically having an employee fill out a questionnaire after you offer the position, but pre-hire, which asks them, have you ever had an industrial injury? If you did have an industrial injury, did you have a permanent partial disability? If so, what is it? I mean, you can go into those types of questions. What we call it most often is a post-hire supplement. And basically that post-hire, the employee will answer these questions to address this kind of information. Okay. Medical exams are physical and psychological.
Are the results given to the employer, or is that private information?
No, you in these kinds of, for instance, if you use a post-hire and ask these questions, that information goes to the employer. But it does not go into the personnel file. It has to be maintained in a separate confidential medical file. Okay? So any of this information about disability, medical, psychological, you cannot keep that in personnel files. It has to be in a private confidential medical file that you retain. And that medical file has to be kept in the nature that it's confidential. You can't just throw it in a file cabinet where anybody can get in the file cabinet and see it. You've got to protect it as confidential information. Psychological examinations, medical examinations, again, are either one are considered medical examinations under the EEOC guidelines and regulations. Okay, so once the individual's hired, again, you can't ask about disabilities or impairment unless something happens and that information is specifically job-related and consistent with business necessity. So how would that come up? A good example of how that can come up is you can have somebody who has some kind of accident, not necessarily industrial. Say they are out riding their motorcycle, get in a wreck, have a bad injury on their motorcycle, and they come back to work, and you, for reasons which are apparent because they tell you or because you can see it looks like this particular person can't physically do the job, then you can do a fitness for duty exam, okay? But you got to make sure that it's job related and consistent with business necessity. So you can't just go have a fitness duty for exam for everybody that comes back from an industrial injury or medical leave. There's got to be a specific reason or indication you believe that person can't do that job. Okay. All right, so suppose you do your post-hire and you ask the employee, do you have any prior back injuries? Do you have any prior impairment related to your back? And the employee tells you that they do not, when in fact they do. Is there a remedy for that situation? Well, I want to talk about a case. Actually, I don't really want to talk about this case. I have two major problems with this case. First of all, it was my case, and I lost it in the Supreme Court. And secondly, it's so darn old, it shows how old I am and how long I've been doing this, which isn't necessarily a good thing. So in this particular case, what happened is an employee lied on an employment application form about specific questions regarding prior back injuries. So, and again, this was pre-ADA, and there was a specific question on the form: have you had any prior back injuries? If so, what are they? What were they? The employee said that he did not have prior back problems when in fact he had a serious prior impairment regarding his back. He was hired in a position that was pretty heavy labor position, and then he injured his back shortly thereafter. The reason the employer asked the specific question on the application form was because this was a heavy labor position. They didn't want somebody who had back issues or prior problems with their back, and they would not have hired this person had he answered the question truthfully. In that particular case, benefits were denied because of the false representation on the application, and that got contested by the employee, and it went all the way through the hearing office, the appeals office, the district court, and up to the Supreme Court. And this is what our Supreme Court said about this. And again, the issue that was presented directly to the court was, can you deny benefits when somebody lies on an application and doesn't answer the question properly and then is injured as a result of the problem that they didn't tell the employer about? And the court said, an examination of the legislative scheme as a whole convinces us where a policy consideration advocates exclusion of coverage, the legislature is perfectly capable of implementing such a policy. Thus, although we are aware that several jurisdictions have adopted the rule proposed by respondent, we join those courts which have held that the rule is not properly adopted by the courts. So the holding in that case was they were not going to prevent coverage in that case because this employee lied on his application, and that employee was entitled to full benefits. They said it's up to our legislature to deal with this particular problem if they think it's significant enough to deal with. And so what happened as a result of that case is that statute. And that statute is NRS 616B-590, and it provides for reimbursement of a private carrier for cost of additional compensation resulting from subsequent injury. What it says is a private carrier who pays compensation due to an employee who has a permanent physical impairment of any cause or origin and incurs a subsequent disability by injury arising out of and in the course of his or her employment, which entitles the employee to compensation for disability that is substantially greater by reason of the combined effects of the pre-existing impairment and subsequent injury than which would have resulted from subsequent injury alone, is entitled to reimbursement from the subsequent injury account if the employee knowingly made a false representation as to his or her physical condition at the time the employee was hired by the employer insured by a private carrier. Okay? There's a couple of points there that are important. One is knowingly made a false representation. Okay? A lot will depend on specific questions they're asked. So, for instance, if in a post-hire supplement you ask the employee, have you ever had a back injury that has caused problems with doing labor or heavy employment, or something along those lines? And that person says no, that response is somewhat subjective, and you can argue whether or not it's a knowing false representation. So when you do these post-hires in these kind of situations, you want to ask very specific questions. Have you ever had a prior industrial injury involving your back? If so, what was it? Did you get a disability rating? If so, what was it? So you want to be specific. You don't want to leave these questions open to interpretation. You don't want subjective interpretation affecting the responses. Yes?
To receive a medical marijuana license, you have to be diagnosed with a disability. Would the employee not tell the employer that they have that license during the post-offer pre-employment questionnaire?
You know, I don't know the answer to that question. And with the medical marijuana issues, a lot of these things are not clear yet because it's such a new law. So I don't know what the answer to that is. What I would suggest that if in the post-hire you ask, straightforward question, do you have a prior impairment or disability? And they do, they would have to respond to that. I don't know that the medical marijuana laws, and I'm not an expert in the medical marijuana laws, would prevent that response on a post-hire. I'd have to look into that. I don't know the answer. I suspect that it would not. Yes?
Name means not recognize medical marijuana as a form of treatment, so you can't discriminate against someone for that because of that.
Yeah, my understanding is that that's the case. There are some indications that state law may contradict that, but
Of course, usually side on the side of federal.
they do, and so it's not crystal clear, but I agree with what you say.
Remember, the doctors are making recommendations, they're not prescribing things, and that right there is a very big difference in how it's looked at and how it's handled, how
Yeah.
we actually respond to it.
Yeah, and in the case of the post-hire, you're seeking information to allow you to assert what is a statutory right under state law. And if you're asking a specific question, do you have prior impairment or disability, that's a straightforward question that doesn't necessarily implicate medical marijuana laws or anything else. And under the regs that the EEOC applies, again, those questions can be as broad as you want them to be. And so if you ask a specific question like that isn't answered appropriately, you may be able to get relief under this particular statute. Okay. The next part of this is that the employer relied upon the false representation, and this reliance formed a substantial basis of the employment. Okay, again, basically what this goes to the issue of whether or not the employee would have been hired had the employer known about the false representation. So you're going to have to be able to show that in the case where the employee makes a false representation, had they told the truth, you would not have hired them. Okay? And I think that what I want to add to that is in the case where somebody, well, let me, I'm going to hold that thought. I'll get to it in just a second. So again, unless you can prove that you wouldn't have hired the person but for that false representation, you're not going to be able to qualify. The third requirement is that there's a causal connection between the false representation and the subsequent disability. So in the situation where you, on your post-hire acts, do you have a prior impairment? And the employee responds, yes, I have a pre-existing impairment involving my back, and they have a subsequent injury in which they break their leg. There really isn't any causal connection there. Now, I suppose you could argue that if they broke their leg because they were lifting something heavy and their back gave out, you might be able to argue there's some kind of a causal connection there. But again, what they're talking about here is impairment related to something that is unrelated to the subsequent injury, so that there's no causal relationship there whatsoever. In that Jensen Precast Goldstein case, there was a direct causal connection because the impairment involved the person's back, and what he was doing at the time was basically lifting a heavy concrete pipe, and his back gave out as a result of that. So there was a direct causal connection there. Okay, that pretty much covers the overview of what we have related to the subsequent injury fund and how you can get recovery from the subsequent injury fund. There's two avenues. One is through the initial method we talked about, where you have a subsequent injury and the employer had knowledge of prior impairment and is able to make the recovery through the statute. Second is where there's false representation that forms the basis of the employment, and then there is a subsequent injury that's related to that. So, yeah.
What funds the fund?
I'm sorry?
What funds the subsequent injury fund? Where's the dollars coming from?
The dollars come from assessments to all insurers, okay? And that is actually provided in, bear with me 1 second here. The assessments, it's a regulation that basically sets it up. It's NAC 616B 731 that provides for those assessments. And the way they do it is they assess all insurers, and of course those insurers pass on the cost of those assessments to employers who paid premium in order to get the insurance. Okay, and again, those assessments cover more than just the subsequent injury fund. So it is, they fund a number of different funds, one being the uninsured employers claim fund. So, all right, that's all of the basic information I have. I'm certainly willing to answer any questions or to talk about any specifics that you may want to talk about on subsequent injury. If anybody would like to check out the DIR insurer's subsequent injury checklist, I have one here you can take a look at, and you'll get a feel for how difficult it is to basically provide the information that's necessary to get subsequent injury fund recovery. So with that, I'll take questions. If there's no questions, thank you very much.
Is this something that just Nevada does? Are there other
No. Other states have subsequent injury funds. Most other states have them. Now, they differ somewhat in how you qualify and what's covered, but the essential concept of, protecting employers who are dealing with disabled and handicapped workers by spreading the cost across other employers and insurers is the same one. So there are states, there are some states that have subsequent injury funds equivalent to our fraud fund, the second one I talked about there. Some states, by virtue of their case law or statutes, preclude workers' compensation benefits when somebody lies on a post-hire, for instance, about prior injuries. So some states deal with it differently than we deal with it, but there are a few that deal with it the same way we do, which is through the subsequent injury fund. Okay? Yes?
If you have an employee who falls during snowboarding on his own time, shatters his collarbone, has a plate, 6 months later is released for light duty, according to a physician, and then works through the light duty increments of full duty, is that knowledge enough to know that where you're putting him is in case he
has another injury?
Yes.
Yeah. That's you're going to be able. Number one, if you're an employer who pays attention to your comp injuries, you're going to, or pays attention to what's going on with your employee
Privately.
you're going to have knowledge of the condition and the problems that it causes, and it's going to be in writing. I mean, you're going to have documents by which you could show that. So if that employee meets the 6% disability, I mean, the fact that they have a plate isn't necessarily going to qualify as a 6% disability, but assuming it does.
But you only have to research that in the event you have an incident.
Yes, yeah, you don't
Okay.
have to know that it's
Okay.
6%.
But, yeah.
Before the subsequent injury. You only have to know that there's impairment or disability that may affect employment. And then if you can establish by written records that you knew that prior to the subsequent injury, you can qualify as long as that disability was 6% or more. Yeah. Yes?
Just wondering if you had a feeling as to how the subsequent injury relief fund would work if somebody's qualified, they're being paid under the fund, and subsequently they somehow bought out or released from that claim, and now there's an aggravation of that condition for reopening purposes.
Okay, and so the hypothetical is that it's being covered under the fund and is somehow
They get a rating at the end.
it's closed out and it's subsequently reopened. It would be an additional cost that's covered.
So we go back to that employer.
You go right back to the fund. Now, you know, if there's some way the fund can argue that liability, you know, has been severed because there's something that happened in
Intervening
between,
auto accident or
whatever.
something
Yeah,
like that.
yeah, not necessarily, but assuming that all of the reopening requirements are met and it's reopened because it's related to the original injury and it's worse, yeah, you're going to get subsequent injury. And you won't have to reapply. You'll simply have to submit additional claim costs and so forth showing the reopening. Yeah, that would be covered.
So you got
Yeah.
the guy that crashes on the dirt bike on the weekend, you hear about it, things are broken, whatever. You just essentially write a summary of what you know, stuff in the medical folder, medical file, all good.
Yeah, and the other thing that you're going to have there, I mean, theoretically, if he's not able to work, you're going to get some kind of medical release. You're going to have medical information that's documenting the problem and the condition and that you knew about it. Okay?
Right.
And so the important point is you knew before the subsequent injury, you retained them in employment with that knowledge, then you're going to get coverage. Okay. I don't see any other questions, so with that, we'll close it. Thank you very much. Hope it was helpful.